On April 17, 2013, the Supreme Court of the United States will hear oral arguments in the case of Salinas versus the state of Texas. Here's a little background. The Fifth Amendment privilege against self-incrimination provides that no person shall be compelled in a criminal case to be a witness against himself. This privilege has long been broadly interpreted, to prevent prosecutors in a criminal case from commenting on a defendant's refusal to testify. Moreover, once a defendant is in custody and Mirandized, given the right not to remain silent and warned that if he gives up that right, it may be held against him, once that occurs, later on, if a criminal defendant refuses to answer questions, the prosecutors can comment on that in a trial. However, courts are split on the issue directly before the Supreme Court in this case. They're split regarding whether the self-incrimination clause is violated if prosecutors tell a jury that before being formally arrested or even in custody, before being Mirandized, a suspect remains silent, for example, by failing to respond to a question that an innocent person might be expected to respond to. Here are the facts. In 1992, Houston police were investigating a double homicide, and they questioned Mr. Salinas regarding his possible role in the homicide. Salinas voluntarily accompanied the police to the police station. He answered questions for about an hour. However, when police asked Mr. Salinas whether shotgun shells that had been found at the scene of the murder would match a shotgun that had been found at his house, Salinas didn't answer, remained silent. Further police investigation led the police to conclude that Mr. Salinas was involved in the double homicide. He was tried, and at his trial, he did not testify. However, a Texas prosecutor sought to introduce evidence regarding his silence in response to the question about the shotgun shells. Salinas' counsel objected that the evidence of his silence would violate his self-incrimination privilege. The trial court overruled the objection, and later on, in closing arguments, the Texas prosecutor emphasized that this silence was an indication of Mr. Salinas' guilt. Mr. Salinas was convicted, and his convictions were affirmed by two appeals courts in the state of Texas, with the second appeals court holding that pre-arrest, pre-Miranda silence is not protected by the Fifth Amendment right against compelled self-incrimination. In oral arguments, counsel for Salinas will argue that the self-incrimination privilege should be extended to cover this type of situation, where a suspect facing non-custodial questioning remains silent. Otherwise, Salinas will argue, a defendant faces a dilemma. If he speaks, his words can be used against him. And if he refuses to speak, the prosecution could argue that his silence is evidence of guilt. Salinas will also argue that prosecutors simply should not be permitted to encourage jurors to draw an inference of guilt from what is inherently ambiguous silence. Even though the pressures of custodial interrogation were not present when Salinas refused to answer police questions about the shotgun shells, Salinas' counsel will argue that the protections of the self-incrimination privilege have already been extended to protect statements that arise in non-custodial situations, for example, in a congressional hearing. Therefore, Salinas will argue, the fact that Salinas had not been Mirandized, was not in custody, should not affect whether he can rely on the protections of the self-incrimination privilege at his trial. The state of Texas will argue that Salinas' selective transitory silence simply fails to trigger the self-incrimination privilege protection for at least two reasons. First, Texas will argue that his silence is not testimonial. That is to say, his silence does not communicate what was in his mind. And second, and perhaps more basically, Texas will argue that the privilege is not triggered here because his silence was not compelled. He was, again, allegedly voluntarily at the police station and not in custody. Counsel for Texas will argue that the Supreme Court should reject the analogy to a case where a prosecutor comments on a criminal defendant's failure to testify at the trial itself, because that situation implicates trial rights and not simply the self-incrimination privilege. whereas here, in this case, Salinas' silence occurred years before his trial. Finally, Texas will argue, even if the court should find a self-incrimination privilege violation here, the conviction should be affirmed nonetheless because any error was harmless beyond a reasonable doubt.